Good afternoon. Today we'll be studying Writ of Mandamus. Because of rain, we are taking online lecture. Good morning, good afternoon, everyone, and a happy rainy season. Today we will discuss an important aspects of administrative law, the Writ of Mandamus. This writ plays a crucial role in ensuring the proper functioning of government bodies and public officials by compelling them to perform their duties. We will delve into the history, meaning, elements, examples, provisions in the Indian Constitution and law, and landmark cases also we will see related to it in this writ. Meaning of writ of mandamus. A writ of mandamus होता क्या है? The term mandamus is derived from a Latin meaning we command. It is a judicial remedy in the form of a command from from a court competent jurisdiction directing public authority, government officer or body to perform public duty. They are legally obliged to carry out. History of writ of mandamus. History क्या है? The writ of mandamus had its roots in English common law. It evolved as a judicial remedy in the King Bench, where it was used to control inferior courts and public authorities. Over time, it was adopted by various countries, including India, where it has been ensured in the constitution as a mechanism to ensure accountability and the rule of law. पहले ये राजा के केस यहाँ होता था इंग्लैंड में. Elements of writs of mandamus देखते हैं. What are the elements? To successfully seek a writ of mandamus, the following elements must be established. 1. There has to be a legal duty. There must be a clear legal duty imposed on a public authority or officer. Public duty. The duty should be related to public function. Demand and refusal. The petitioner must have demanded the performance of the duty and the demands must have been refused or unfulfilled. Right of the petitioner. The petitioner must have a legal right to compel the performance of the duty. No other advocate remedy. There should be no other advocate legal remedies available to the petitioner. These are the important elements. Now let us see some of the examples of writ of mandamus. इसका example है, if a municipality refuses to grant license or permit to an individual or entity who has fulfilled all the legal requirements of the aggrieved party can seek a writ of mandamus to compel municipality to issue the license or the permit. Example number 2 देखते हैं. If the university fails to declare examination results within the stipulated time, student can approach the court for a writ of mandamus directing the university to declare the results. One more example we have to see. We will see. If the government department fails to grant due pensions to retired employees, the affected individual can seek a writ of mandamus to compel the department disburse the pension. Provision in the Indian Constitution of the law regarding these writs. As you all know, the writs are mentioned in Article 32, but the writs are in India. The writ of mandamus is enshrined in Article 32 and 226 also of the Indian Constitution. Article 32 allows an individual to move to the Supreme Court for the issue of writs for the enforcement of fundamental rights. Article 226 empowers High Court to issue the writs of enforcement both फंडामेंटल राइट्स एंड अदर लीगल राइट्स. इसके कुछ लैंडमार्क केसेस भी देख लेते हैं हम लोग कि रिट ऑफ मैंडमस के लैंडमार्क केसेस एक दो. जैसे रत्नाम म्युनिसिपलिटी वर्सेस वर्धीचंद 1980 का केस है, बहुत फेमस. इन दिस केस द सुप्रीम कोर्ट डायरेक्टेड द रत्नाम म्युनिसिपलिटी to perform its statutory duty to clean up the public streets and drains. It highlighted that excess of financial incapacity would not be absolute public authority for their mandatory duties. Other case was Maneka Gandhi versus Union of India 1978 का केस था. This case involved the refusal to issue passport, where the Supreme Court held that the mandamus can be issued to enforce the right to travel abroad, thus recognize the personal liberty under Article 21 of the Indian Constitution. So, students, the writ of mandamus is essential tool in the hands of the judiciary to ensure that public authority and officers perform their statutory duties. It serves as a safeguard against administrative inefficiency and arbitrariness by compelling the performance of public duties. It upholds the rule of law and ensures that the citizens' rights are protected. Underlining and utilizing this writ is crucial for maintaining accountability and transparency in governance. Thank you everyone for attending. Even in this rainy season, tomorrow we will have an offline session. Today we had online. If you have any questions or require further clarification, feel free to ask. Thank you. Good day.